Well, good morning, good afternoon, good evening to all of our attendees online. Welcome to World Arbitration Update, our third annual event. It's a real pleasure to have everyone here today. We've had a great conference so far. We're on, I believe it's day 5. It's kind of a blur. We've had 18 fantastic sessions with 2 speakers over the last 4 days. We started the end of last week on Thursday and Friday in Mexico City at the National Autonomous University of Mexico with an in-person conference. And the main topic of discussion was arbitration in Latin America, as well as investor-state arbitration. And we've been moving around the world, addressing and updating issues concerning arbitration, commercial arbitration, investor-state arbitration, and public international law in Africa and the MENA region. We started that on Monday. We've traveled to Asia and Oceania, and now we're going to touch on issues related to Europe. And as you can see, when you go to our website, the wide range of topics that we've tried to cover and the amazing panelists and moderators that have participated, it's very much reflective of the objective of World Arbitration Update to be a truly global endeavor, reflecting the worldwide nature and diversity of international arbitration. It's practitioners, it's arbitrators, all of the support folks that make up the international arbitration community. It's really not just something that occurs in New York and London anymore. We are, as we are here in this panel, we are, the international arbitration is in Sydney, it's in Hong Kong, it's in South Africa, it's everywhere. And we've really made an effort to reflect that worldwide phenomena. And today's session, which I don't want to neglect to mention, is titled the ECT, Investment Treaties in Europe and International Arbitration Awards Unfavorable to European States. And then next line is Demystifying the Conundrum of International, Regional, European, and Domestic Law. A bit of a handful, but as you can see, a really key and very current topic. And we're really looking forward to a great panel. And as part of my duties, I'm going to introduce our moderator, Marin Carlson. Marin is a partner and co-leader of the firm's of Sidley Austin's, global arbitration, trade, and advocacy practice. And she focuses her practice on international investment disputes with an emphasis on investor-state arbitration. She represents both cross-border investors as well as respondent governments in ICSID and UNCITRAL arbitrations under investment treaties, BITs, and free trade agreements, including NAFTA, USMCA. And she, counsels clients in various sectors, ranging from financial services to energy to infrastructure development, on the implications of international trade and investment rules for their global operations. She is a graduate of Princeton and Yale Law School, as well as did her Dartmouth College BA. And she clerked for the U.S. Court of Appeals as well back when she was a much younger lawyer. But, as you can see, Marin has fantastic experience and background and really, one of the best people to do this panel. And I'm really looking forward to it. And I'm going to sit back and listen, and I'll pass the microphone over to Marin.
Thank you so much, Ian, for the lovely introduction, and welcome everybody. We are, as Ian said, spanning a lot of time zones. So good morning to anyone in the US, good afternoon to those of you in Europe, and good evening, and thanks so much for the late hour for those in Asia and beyond. We're very happy to have everyone here today, as Ian said, he worked his way through the mouthful of a title of a panel, which is indeed formidable. I will summarize our topic as investor-state arbitration in Europe and the future thereof. But if we can indeed demystify a conundrum, we'll be doing very well this morning. The good news is that we have an excellent panel to help us with that process. We're going to start off with a sort of ground setting or level setting presentation by Daniela Olivia Gicajanu, who's at the Center for Advancement of the Rule of Law in the Americas, where she's focusing on international investment law policy and arbitration, particularly in Latin America and the Caribbean. She has an LLM from Georgetown, as well as one as well from the College of Europe in Bruges, where she specialized in European Union law. Can be very handy for this topic, and also had acquired experience in EU litigation, regulatory, and investment law while she was in the legal services of the European Commission and the European Securities and Markets Authority. She's also, I will mention, the marketing director for the Campaign for Greener Arbitrations. So Daniela is going to start us off with a presentation, and then we're going to have commentary from the rest of our panel. And that's a very distinguished panel as well. So we have with us Nikos Lavranos, who is the first Secretary General of the European Federation for Investment Law and Arbitration, and he is also the founder and owner of NL Investment Consulting, which is an external legal advisor for numerous law firms. In addition to being a partner and of counsel at several European firms, where he specializes in international investment law and arbitration, EU law, WTO law, and public international law. And he was previously chief negotiator for Dutch BITS and at the Dutch Ministry of Economic Affairs, and later at the Dutch Ministry of Foreign Affairs. So brings that direct experience as well. Then we're joined by Laura Rees-Evans, who's an English solicitor advocate and counsel at Vieta LLP. Where her practice focuses on public international law and international investment arbitration, having represented both claimant investors and respondent states, including under intra-EU BITS. And in 2021, Laura co-authored an academic paper that was published in Arbitration International about the EU termination agreement, analyzing the compatibility of its provisions with investors' fundamental rights under the European Convention on Human Rights. Joining us also is Chester Brown, who's professor of international law and international arbitration at the University of Sydney Law School. He teaches and researches in the fields of public international law, international dispute settlement, international arbitration, international investment law, and private international law. In addition to being as well a barrister at 7 Wentworth Selborne Chambers in Sydney, and an overseas member of Essex Court Chambers in London, and maintains his practice in those fields, having been involved as counsel, expert, and arbitrator. And last, but probably the person needing the least introduction in this forum is Jose Antonio Rivas, who's the founding partner of X Strategy in Washington, D.C., and chair of its international arbitration and investment law, international law practice. He works as an international counsel in investment and commercial disputes, also serves as an arbitrator, and provides advice on public international law and investment law to sovereign clients, to state companies, and to investors, and is particularly well known in this setting as the co-founder of World Arbitration Update, in addition to being the co-founder of Washington Arbitration Week, another great event happening later this year. And he was also formerly lead negotiator of investment treaties for the Republic of Colombia and a former legal counsel at ICSID. So as you see, this panel is very well positioned to demystify the conundrum of investment arbitration in the EU, but it's still going to be a heck of a project. So thank you for joining us for that. And we're going to start off with Daniela leading us off with a presentation to make sure that we're all on the same page as we start into this complicated and challenging but exciting topic.
Good morning, good afternoon, and good evening, everyone. Thank you, Maureen, for the kind introduction, and thank you, Jose Antonio, Ian, Maria Lucia, and the entire X Strategy team for inviting me the second time to be the presenter of an ECT panel. I will share some slides because indeed there is a lot to unpack here. So yeah, you can see the slides, I suppose. So The agenda for today would focus on some key points: the relationship between the investment law, EU law, and European Union law, disputes in investment law and EU law, the enforcement challenges, and then a bit on the ECT, because in the EU it's quite important, and also for the international investment law world, and then what is the current state of affairs and what we should expect from the future. So for those who don't know about EU law, it has some particularities. It's a supranational law, so it's above the national law of its member states. And the Court of Justice in Luxembourg is the only interpreter of the EU law according to the treaties of the European Union. Then it has some characteristics, and two of those most important are the primacy of EU law and the autonomy of EU law in consideration with other norms, national or international norms. Then I have this line on the ECT, the Energy Charter Treaty, because there are many disputes, ongoing disputes with intra-EU parties. And since a very well-known, perhaps not for everyone, but since the Comstroy case, the European Court of Justice considered that when you have two EU parties, then the ECT becomes EU law, and then that's an intra-EU dispute. Then there is a lot to unpack here. The investment law regime and the EU law regime, they coexisted well, let's say, before March 2018. Though I will not talk about how was the relationship before, because there is a lot of policy and politics to unpack, but they coexisted quite well. The problem came to surface when the EU started to expand to the CE countries, and then the capital exporting and capital importing countries started to have disputes, which were actually between EU member states. There was a lot of debate until March 2018 of what norms should prevail, whether the international investment norms in the BITs, in the intra-EU BITs, or the EU law. And that debate was settled in March 2018 by the Court of Justice of the European Union in the Acmea case, or the Slovak Republic versus Acmea, which was a game changer and offered the legal base for the European Commission and for the EU member states to terminate the intra-EU bids. What happened, the highlight of that case, was that the intra-EU bids, especially the ISDS clause in intra-EU bids, is incompatible with EU law. And what happened next after 2018 is more of a chronological and logical sequence, because in 2019, the EU member states, back then we had also UK as a EU member state, issued some political declarations regarding the termination of all the intra-EU bids by the end of 2019. Well, it didn't happen like that, because the political declarations were one thing, but in reality, the termination of these intra-EU bids was a bit more complicated. And this is why in 2020, during the pandemic, 23 EU member states adopted this so-called termination agreement of intra-EU bids and their sunset clauses. We had 23 member states. We don't have Sweden, Finland, Austria, and we don't have UK. UK was supposed to sign it or to be part of this treaty according to the withdrawal agreement, but it didn't sign. So because of this situationship, the EU Commission started some infringement actions against Sweden, Finland, Austria, and against the UK, because they are not part of this treaty and because they still have intra-EU, well, for the UK now, those are extra-EU BITs. I checked, and the termination agreement is now ratified and enforced in all its contracting parties, but they ratified it and incorporated in the national law at different times, not exactly after the adoption or entering into force. Then we moved to 2021, which was quite a year for the EU law and investment law debate, when we had the Peel Holdings case, where another preliminary ruling from the Court of Justice, where the Court of Justice basically held that the ad hoc arbitration agreements between EU member states and EU investors, they also contradict EU law. So it's not only the ISDS clause in an intra-EU bid, but also if we have an agreement between an EU member state and an EU investor. And that was basically the debate on intra-EU bids. The problem was the debate on ECT, because in 2019, some of the member states said that ACMEA applies also to the ECT. There was a lot of debate among scholars, practitioners, whether this is true or not. Well, in September 2021, the CJEU had the opportunity to rule whether in a dispute, which is not necessarily, this one is not a dispute between two intra-EU parties, but because it was before the Court of Appeal in Paris, and the Court of Appeal raised a preliminary question, which landed in Luxembourg before the CJEU. The Court of Justice had the opportunity to rule on whether, when we have intra-EU parties in an ECT disputes, whether that would be contradictory, the ISDS clause in the ECT would be contradictory to EU law or not. And following the sequence of ACMEA and the termination agreement, indeed the Court of Justice considered and held that the ISDS clause in the ECT as it stands at that time and it stands today would contradict EU law in case the parties at the dispute are EU parties. So if we have an EU investor and a EU member state, which in the EU disputes, these are the typical cases. In 2022, we have an interesting development in a case against Spain. This is an arbitration case before an SEC tribunal, where it was the first time when the intra-EU objection was admitted, and it was the first time in 64 cases. What is the issue with the intra-EU objection? Well, even before ACMEA, but especially after ACMEA and after the termination agreement, the respondent states they used to raise this jurisdictional objection on the incompatibility between the BIT and the EU law. And then with ACMEA, the member states of the European Union now have a legal basis to say that the tribunal doesn't have jurisdiction, or the state didn't give its consent to the arbitration. And now in the present, what's happening, and we are also here talking about it, is the ECT conundrum and the modernization process on one hand, and on the other hand is the number of disputes that are now ongoing, especially against Spain, but not only because there are other countries which start to be quite a frequent respondent. Spain has the majority of the cases, but also Romania is a third country with ongoing cases, and probably, considering how the situation is going now, there will be more cases. For example, yesterday there were rumors that Ireland might have its first investment arbitration case, and it will be an ECT one. Okay, now that we know how we stay, then with the disputes, we have also the enforcement part. And I title this as challenges and opportunities because there are challenges, especially if we want to enforce in the EU. Because since ACMEA and the termination agreement, and now COMSTROI, there is very difficult, if not impossible, to enforce an investment arbitration award in an EU member state. And why? Because of the principle of sincere cooperation and the other two principles I mentioned before, the autonomy and primacy of EU law. So a national court will have to give primacy of EU law. That means they have to implement, they have to see whether enforcing the respective award would be compatible with EU law, so with ACMEA. And that will be not compatible. And in this case, if the National Court of a member state of the European Union would enforce an investment award, that would trigger some consequences. And one of them would be a non-compliance with EU law, which would reflect in an infringement action against the respective member state. And this happened actually recently against the UK because of the Mikula case, where the UK Supreme Court decided that the enforcement can go on, but they were not a member state of the European Union. However, according to the withdrawal agreement, they had still to respect the principle of sincere cooperation. And because they didn't, the European Commission started infringement action. And that case is pending now before the Court of Justice of the European Union. Again, another recent development in intra-EU enforcement is the Mikula case in July 2022, when the Court de Cassation from Luxembourg denied the enforcement of the award, especially focusing on ACMEA and the termination agreement. The enforcement outside the European Union presents some opportunities, and we have the US courts, we have the UK courts. Recently, and Chester will talk more about it, we have the Australian courts. In the US courts, if we enforce under ECT or under the New York Convention, under ECT, a typical case is Mikula, but not only Mikula. Mikula had an interesting development. Is a case which started back in the 2000s, and the award, the investors, they could not enforce in EU member states, but they were allowed to enforce in the US, especially in the District of Columbia. Then enforcement under the New York Convention, we have like a case study, COMSTROI. COMSTROI is a back and forth case in the EU because the award was annulled recently by the Court of Appeal of Paris. But the US District Court of Columbia and the US Court of Appeals allowed the enforcement to proceed in the US. And with the ECT awards in the past months, 2 or 3 months, we had some interesting development, and there was a split between the District of Columbia judges. In 9-1 holdings versus Spain in February, one judge allowed the enforcement to proceed, considering that there is jurisdiction and the sovereign is not immune to the enforcement. Whereas in March, this year, in Blasket Renewables versus Spain, another judge from the District of Columbia considered that actually Spain never consented to have arbitration, and therefore it didn't allow the enforcement to proceed. Those 2 cases and the third one, they are in an expedited appeal before the US Court of Appeals for the District of Columbia. So probably what will happen in the appeal will tell us how the US courts will see these enforcement cases, because there are many enforcement cases in ECT or intra-EU bids pending before, especially before the District of Columbia courts. In the UK courts, I mentioned the Mikula case and the UK Supreme Court. That's enforcement with a caveat, and probably Laura will talk more about it. But since Brexit happened, investors, they see UK courts as a fertile soil to ask for an enforcement, which is true. unless you look at the withdrawal agreement and the infringement action started by the European Commission, that might deter a bit the investors. In the Australian courts, there is this interesting case where the High Court of Australia may allow the enforcement, but made an interesting separation between the immunity of enforcement and immunity of execution. But I'll allow Chester to talk more about it in the minutes to come. Now, the Energy Charter Treaty, I call it a derailed modernization saga. For those who don't know, this treaty was adopted in 1988. It's a multilateral trade and investment treaty to promote energy trade and investments in energy. It has more than 50 signatories, and not only EU member states, but also other contracting parties. And again, this is one of the most used investment treaties in investment disputes. As you can see, there are more than 150 proceedings using this treaty. The modernization of this treaty started in 2020. There were 15 rounds of negotiations, and in June 2022, the modernization process finished. Why was necessary the modernization process? Well, because at the moment when it was adopted, no one was talking so much or nothing at all about climate change. So that needed to be the parties need to find a remedy, and the European Union advocated a lot for the modernization in order to align the investments in the EU with the Green Deal, but also with the Paris Agreement. So it was seen as a necessity. Everyone believed that when this modernization ended, all the contracting parties will adopt the treaty. Well, actually, it didn't happen like that. It was expected in November 2022, a vote, but the vote didn't happen because Poland announced in September or October that they will withdraw from the treaty. And following Poland, also Germany and France announced their withdrawal, which actually derailed the modernization treaty and the modernization process. And until now, it's kind of in a limbo. And from now, we have another 6 member states which made a political declaration about their intention to withdraw. Of course, there were some reactions from the European institutions. The EU Parliament adopted a resolution asking the EU Commission and the EU member states to withdraw, and the EU Commission to lead the withdrawal from of the European Union itself. And also the EU Commission published a white paper on the potential options that the EU member states might have, because we have to mention one thing, that not all EU member states declared that they will withdraw. There are still a considerable amount which don't say anything for now. Probably they will follow the lead of withdrawal, but we don't know for sure now. And that was basically a sum up. And how are the current affairs? Well, the current affairs are that the termination agreement from 2020 is ratified by all its signatories, which means that almost all intra-EU bids and their sunset clauses are now terminated. But the bids between the Finland, Sweden, Austria, and with a caveat with what's happening with the UK. We have still pending arbitrations involving intra-EU bids, and the intra-EU objection is rejected massively by the arbitral tribunals. The enforcement level, everyone is expecting to see what's happening with the expedited appeal proceedings before the US Court of Appeals for the District of Columbia, and also to see how the Australian courts and the UK courts will look at these disputes, and especially the enforcement of these awards in the future. With the ECT modernization, that's suspended. The vote, which was supposed also to take place in April, didn't happen, so we don't know what might happen. We also know that from January next year, France, Germany, and Poland will not be part of the ECT, which actually from that moment, it triggers the sunset clause of 20 years. So until 2044, they will be, the investors can still use ECT in a dispute against these three countries. And as I mentioned yesterday, Ireland received the news that it might face the first ECT claim, and another case against Spain, where we can see that the ECT, the arbitral tribunal favored the investors. So which means for us that the arbitral tribunal didn't consider the intra-EU objection and whether the ECT, when applied between EU parties, is EU law or not. What happens now? Well, it's a little uncertain on the ECT territory, but not necessarily on the intra-EU bits. Thank you very much, and I pass the floor to Marie.
Thank you, Daniela, and thank you for setting the stage. Now that you've summarized all of this in 20 minutes or less, we've set a great floor for everybody to continue the discussion. But I come away with it thinking if everybody should now have more questions than ever. So so Nikos, why don't you start us off by sharing some thoughts for us on how we should think about this intersection of EU law, investment treaties, and where that has led us to the current state of affairs that Daniela has just set out.
Yes. Well, thanks very much, and welcome everybody to our panel. It's a great pleasure to be here again. We had this last year as well, and this was a wonderful experience. And well, I don't have so much to add to Daniela's presentation, but I will dig into a few more specific elements, if you allow me. I think maybe for a start, it is useful to remember and to stress that there is really a difference between the bilateral intra-EU bids and the multilateral ECT. I think that's often forgotten in the discussion. And the reason why I'm stressing this is that whereas under the intra-EU BIT situation, the Commission had a relatively large control over the member states, and the member states themselves were relatively united in enforced essentially by the ACMEA judgment to get out of their intra-EU bids, although, as you mentioned, not all of them have done so. The situation is much more complicated with the ECT. And one of the reasons is because you have rights and obligations of non-EU ECT contracting parties, and subsequently also the investors. And I think that is an important problem, and that means that the member states claim and assert their own competence with regard to the ECT as a treaty party. And that's what has happened, right? Because I think it is quite unusual, and in my experience of EU law, and I'm doing EU law for approximately 25 years now, since I was ever a student, I've never saw a situation where the European Commission was unable to control the member states in regard to treaty negotiations or treaty developments, so to speak, right? It's the first time, in my opinion, that the European Commission was unable to ensure a controlled, coordinated approach. And I think that's quite interesting. Maybe it's also, if you like, a sign of the times, right? That it's possible for the EU member states and the European Commission to coordinate all those little naughty kids in the kindergarten, if you like. And I think that's what has happened. And the political pressure apparently has really mounted because, again, we should, and I would like to stress that in June last year, we had an agreement in principle by all ECT contracting parties, right? I stress this, by all ECT contracting parties, including all EU member states and the EU itself, right? So what has happened after the summer last year, we don't know. But it's really interesting to see this flow of announcements of withdrawal, and indeed some of those 3 countries you mentioned have actually come through with that. We should also mention actually that Italy has been out of the ECT even for a couple of years as well. So we have now the situation which I find really interesting, and I cannot believe that this is something that the European Commission or for that matter, the European Court would like to see, is that we have a multiple fragmented ECT situation, right? So we have 4 EU member states, Italy, France, Germany, Poland, who are out of the ECT, which means the 20-year sunset clause applies, but also means that apparently, we don't know, at least from an EU law perspective, the disconnection clause, the de facto disconnection clause would apply, right? Meaning that, at least from an EU law perspective, intra-EU disputes against Italy, France, Germany, and Poland wouldn't be possible. I question this under public international law, but from an EU perspective, that's the situation. You can see already the situation, the trouble we are into, because we have the other 20 EU ECT contracting parties who are still, as we speak, in the current ECT, right? Which means the full broad defined FET, for instance, standard applies, just to mention that, right? Which means also all investments, including in the fossil fuel, would apply, right? And arguably, again, we don't know about the de facto disconnection clause. Now, what has happened is, and I only found, strangely enough, one small report in Reuters a few weeks ago that the Swedish presidency has proposed that to the member states that they would all withdraw from the ECT, right? All, but allowing for the option for some to ratify the revised one, right? Which creates then a funny situation, because imagine, let's say, 5 or 7 member states really like the revised ECT, which I think is a good idea, because it is very good also in terms of making it Paris Agreement proof, reducing the sunset clause to 10 years, at least for the fossil fuel, and having a formal disconnection clause in the ECT. So everything that the EU wanted was in the revised ECT text, right? In any event, so now we have, let's say, 7 EU member states who ratify the revised ECT. What would that mean in terms of fragmentation, right? What would that mean, for instance, for a, let's say, a Spanish investor trying to bring a case against, let's say, Bulgaria, who has signed the revised ECT, right? And what does it mean in particular when that investment applies to fossil fuel, for instance, right? Just to describe the situation. So we really get a very fragmented situation here, and I do not see that the Swedish proposal will help clarify the situation. So zooming out of this, and I can go on forever, as I said, the revised ECT contains a formal disconnection clause, but it also contains a CETA-style limited FET clause, which is also very important for the EU, right? There are really a lot of problematic issues here, and this brings us back to the question of, if you like, conflicts of regime here, right? We have several regimes that are in conflict. On the one hand, we have EU law. On the other hand, we have public international law in the form of the ECT, but also, and the other speakers will go into that, also with regard to the ECT Convention and the UNCITRAL and any other New York Convention, any other international agreement that is related to the recognition and enforcement of awards. And on the other hand, you also have the problem that you have potentially, as it looks now, several ECTs applicable within the EU, or at least with regard to EU member states, whether being in the current ECT, whether being in the new revised, or whether having left the current ECT. So I think this really creates a lot of problems, and they cannot be solved, in my view. They cannot be solved in the usual way of the conflicts rules that we have in international law. And I think this is a serious problem because investors do not have any legal certainty anymore. And I think that is something that we forget about. At the end of the day, it is about access to justice. And we don't know anymore, because the original idea was obviously that investors would not have access anymore to intra-EU ECT arbitration, right? But that has failed partially. So you have the situation that some EU investors against some member states might still be able to use arbitration, and others might only be left to go to the domestic courts of the EU member states, right? And that, of course, creates huge problems, I think, in terms of non-discrimination, access to justice, etc., but also in terms of the level of compensation that you arguably will get from the arbitral tribunal or from the domestic courts, or at the end of the day, maybe even from the courts of human rights. So to conclude, because I don't want to take too much time, I think this situation is unnecessarily become very complicated. And I don't know whether the EU member states have understood what they have created here for a monster. It is good for us as lawyers and for academics and for this panel, but it is certainly not good for legal certainty, for clarity, and for investor protection. And then I conclude now, but I think, of course, at the end of the day, it will take a few years. The end aim, the final aim, will, of course, be also to terminate completely access to arbitration also for intra-EU ECT disputes, right? That is the end aim, the final aim of the EU institutions. And the question is whether this is a good thing or a bad thing. But I will leave it here because I know the others have also a lot to say. Thank you.
Thank you, Nikos. And for our panelists, I think I'm going to exercise the moderator's privilege of jumping ahead on our plan just to make sure that everybody gets a chance to intervene. I mean, Nikos has given us a lot to chew on here with the idea of conflict of regimes. I love the idea of having 3 or 4 ECTs operational now, because, you know, one was fun enough, but why not have more? So maybe let's move on forward. Jose Antonio, I know that you've given some thought to how particularly tribunals and courts should be thinking about wrestling with these different decisions that are coming down and the different dynamics and developments in the European space. I love Nikos's idea of trying to keep the kindergartners in line, but how should bodies that are now trying to deal with this sort of developing body of jurisprudence think about it and apply it in cases to come?
Thank you, Maureen, and I would really honored to be with my co-panelists here, and I would the perspective that I would like to bring to the table is that of international law, public international law. So when you ask how should courts perceive the current problems that are going on with respect to the ECT based awards, and also possibly with respect to the intra-EU BITs based awards, the perspective that I would like to bring is I wish that national courts did understand what is part of international law and what is not part of international law, and I would like to summarize that by phrasing it in the following manner. The ECJ itself is not the ICJ, and what I mean by this is that the ECJ, the European Union Court of Justice, is a regional court. It may be the highest regional court in Europe, but it's not the International Court of Justice, nor does it have the prerogative or legitimacy under international law to determine what is in compliance with international law and what is not in compliance with international law. And that's a summary of what I want to say. I will try to be fast. I looked into and I reflected why are we referring to this matter so much? Why are doctrinants and arbitrators and attorneys in all over the world, including Latin America and Africa and Asia, referring to the ECT? Why are they citing the ECJ, etc.? And my thinking was that of the international rule of law. I believe that with this problem, and upon further reflection, the only conclusion was how important is the international rule of law currently, including for Europe, and it couldn't be more important given the situation of the invasion of Russia to Ukraine, and the plea is not so much now simply to calling off the European Union and to say, well, they're not complying with international law, but also to plea for a reflection in terms of it should lead by example in terms of compliance with international law. So that is one important but still minor point. Talking so much about the international rule of law, I looked into various definitions, and unfortunately there's so many, perhaps hundreds. I liked one by Robert McCorkdale with respect to the international rule of law. He indicates that the international rule of law comprises legal order and stability, equality of application of the law, the protection of human rights. I mean, he comes from a human rights background, through access to justice and the settlement of disputes before an independent legal body. And I emphasize an independent legal body. The independent legal body here is not the ECJ. It's not independent for purposes of intra-EU matters or ECT matters. And of course, he goes into the lack of compliance with the international rule of law. Doesn't mean that the international rule of law does not exist. interestingly enough, some commentators have compared the compliance or lack of compliance with international rule of law to what used to go on in the medieval period. Everyone complied with it as long as it didn't have to do with them. But when not complying, even so, they try to justify it. And justify it with arguments, because we're all lawyers, and at that time there were all lawyers as well. So I believe that this is what may be going on. I want to now jump and refer to what Daniela indicated in terms of some of the principles that are applicable or applied by the ECJ, including the principles of consistency with the European Union law, the principles of autonomy and primacy of EU law, and ask one particular question: are those principles, what kind of principles are they? The important fact is, going back to one of the statements that Nikos made, the important part is to identify the regime that we are under. Those principles are absolutely binding, but where? They're binding under EU law. They are not principles of public international law. They're not general principles of law. They're not customary international law. Those principles have a framework, and that frame is EU law. And yes, they're binding, but within the EU, they're not binding as a matter of public international law. So that leads us to ask ourselves the question: why is this such a big problem? And my only explanation is perhaps better answered with a question. Is the ECJ a court that has a better pedigree than any other local court, than any other regional court? Yes, perhaps, historically there has been a very significant contribution, but that doesn't mean that the decisions or opinions of the ECJ should be supra-international. They may be supranational within the EU regional framework, but they are not supra-international. So having understood what the consequences of the ECJ opinions should be, which should be within the framework of the European Union, then comes the question of what has been going on in the current cases. I won't refer to specific cases, but I want to call the attention of a certain facts, a certain number of facts that are present in, I believe, most of the BIT law cases, and also the ECT awards. The Energy Charter Treaty was signed by the European Commission in December 1994. The Energy Charter Treaty was signed, was entered into force on April in 1998. The Comstroe opinion in the of the European Court of Justice came out in 2021. So we're referring to more than 20 years later. During that time, the lack of consistency between BITs and the European framework, or the lack of consistency between the ECT and the European framework was not called into question. there is an issue here of retroactivity in the law, which I believe that courts should look into very, very closely and very deeply. And just to call off and indicate a little bit of what has been going on in U.S. courts, the non-acceptance of applying the law in a retroactive manner was a principle that was applied by U.S. courts in the Corporación Mexicana versus Pemex case, and by the Second Circuit in the U.S. And the notion here was that even though a Mexican local court annulled an award, an international commercial award, that annulment was not embraced by the U.S. courts because such annulment was based on a retroactive application of Mexican law. Similarly, here, it could be said that what the ECJ and some European states are doing is applying their interpretation in a retroactive manner when the EU and many European states signed the treaty and are parties under international law to those treaties. So I hope that the courts, and it seems that the Australian courts are following a respectful approach to international law, and we'll see what the U.S. courts do. I hope that the courts understand the difference between, as I said at the beginning, ECJ and ICJ. Thank you, and I rest here my words.
Thank you, Jose Antonio. So I guess, Laura, the question is, do the UK courts need an expert opinion from Jose Antonio about how they should proceed, or are they already on the right track?
Thank you, Marin, and thank you to WIU for the invitation to speak on this panel. It's one of my pet topics, as many of my fellow panelists know, and probably a few of the people watching know as well. So yeah, I mean, I think the UK position is maybe not fully clear yet. We've had the Mikula case in the Supreme Court that Daniela mentioned at the start, and that case didn't directly deal with the Acmea-Comstroy sort of implications, because it was just dealing with the question of ongoing proceedings in the EU in relation to whether the payment of the award constituted state aid. So that was the question there, and obviously the court had to deal with the question of whether the UK's pre-accession obligations under the ICSID Convention trumped its obligations under EU law. And its decision in that respect suggests a sort of pro-investor or pro-award stance, pro kind of stability of award stance of the UK courts. But obviously, as Daniela also mentioned, the UK has been taken to the CJU over the Supreme Court's decision in that case. And under the withdrawal agreement, the UK will be bound by the CJU's decision. So we wait to see with bated breath what the CJU will say on that. I think the proceeding is in early stages and there's no real information on it on the CJU website. I think it was referred about a year ago. So we may be waiting a year or more before we have a decision. But in the meantime, there is the proceeding in Antin, which is a proceeding arising out of an award against Spain under the ECT, which is currently in the UK courts, where the investor award holders are pursuing enforcement of their award. And as I say, it's in quite early stages. The High Court earlier this year refused permission for the European Commission to intervene. But aside from that decision, we haven't seen anything really of substance from the UK courts. So that will be the first time that the UK courts are called upon to really grapple with the issues that arise out of Acmea and Comstroy in relation to ICSID awards. There's no proceeding, so far as I'm aware, in the UK courts in relation to any New York Convention award. So it remains to be seen, but I have some faith in the UK system, and I think particularly, you know, it's in a different position to EU member states now post Brexit. It may feel somewhat more latitude to uphold ICSID award. I mean, ICSID awards, to me, I think that it's just hard to see how any EU member state court can refuse enforcement of ICSID awards. I think it's such a high threshold to do that, but particularly in the UK, I think it will really be a challenge to convince a UK court not to abide by its ICSID obligations and agree to enforcement of an ICSID award. But we'll see. And as I say, the MICULA proceedings before the CJU may come to have some indirect impact in that case. So I think it's a case of watch this space for the UK. But just wanted to pick up on a couple of other threads that have run through the presentations today, and sort of the UK angle on that and a bit of a broader angle. You know, I think there was maybe some hope that this mess that the EU is kind of this hole that the EU is going further into, that the UK could sort of be removed from that via Brexit. And I don't think that's fully happened. I mean, obviously with respect to the ECT, I think it's much cleaner. The UK is now out of the EU, and so it doesn't have those limitations that other EU member states have. And the UK has reserved its position on the ECT. We don't know yet if the UK will be one of the states that chooses to withdraw, but it's not looking that way. But on investment in other agreements, so the intra-EU BITs that it had, the UK appears to have silently or quietly over the past couple of years terminated those agreements, or at least all but two of them. I think two of them remain in force, but there are, we've seen evidence that 9 of the 11 intra-EU BITs have now actually been terminated, as I say, without any fanfare at all, but they've gone, including their sunset provisions, or purportedly sunset provisions. And the UK-EU TCA doesn't really have investment protection. There's no rights, doesn't create rights for investors. There are no substantive investment protections akin to what you would see in investment agreements. There's no ISDS. So really there's nothing, there's no replacement there. And so far as the UK is concerned, we're really left with the ECT and nothing much else. But that takes me to a sort of broader point about, well, then what's left within the EU, and you know, how do we resolve this conundrum? Is there anything else we can look to? And I in this tend to look to the ECHR as this bastion of sort of stability in otherwise fairly choppy waters. And I wonder whether the ECHR will sort of become a more interesting forum for investors in terms of, you know, claims about violation of the right to property, right to a fair hearing. You know, it's naive of the Commission and member states to think that we have a panacea in Europe where all domestic courts are capable of affording investors a fair hearing. And, you know, I've seen in the cases I've personally been involved in that it's just not the case. And so maybe in that the ECHR has a role, albeit a very different one to what intra-EU BITs have offered. There's obviously different hurdles like the exhaustion of domestic remedies. The approach to damages is very different. The enforcement of ECHR judgments is very different. But I think that potentially could be a kind of maybe a bastion of hope. And similarly, potentially also a role for that court in relation to awards that have already been issued, particularly those non-ICSID New York Convention awards, where either they've been subject to set-aside proceedings or enforcement has proved to be impossible, essentially because of the fallout from ACMEA and potentially even the retroactive application of cases like ACMEA and Comstory to awards rendered under intra-EU BITs. And I think it's a matter of time before we see that. I mean, when you look at for example, the way that ACMEA has argued its case in the German courts, when it's resisted the set-aside and subsequently before the Constitutional Court, it's speaking in the language of human rights, fundamental rights. And to me, it may be because that's appropriate before the German courts, but it's also setting itself up to say that it's exhausted remedies before the German courts so that it can go to the ECHR. So I think it's a matter of time before we see those cases, and it'll be interesting to see whether the ECHR, the European Court, is prepared to lock horns effectively with the CJEU on those issues.
Yeah, that could create a really fun, I mean, to play on the conflict of regimes that Nikos was talking about. I mean, literally to have the conflict of courts could be interesting to see. So
yeah,
maybe if I just can add a footnote, not to forget that recently Commission President von der Leyen has stated that as soon as possible the EU would accede to the ECHR, notwithstanding the fact that we have two opinions in the past decades where the European Court of Justice has refused accession of the EU to the ECHR. So indeed, if that's going to happen, then we will have indeed effectively a fight between the two European courts.
So yeah, Chester, what are the Australian courts making of all of this?
Thanks very much, Marin, and thank you very much to the organisers for the invitation to be involved in this excellent panel. Really live issues, and as Marin has just prompted me, I'm going to be speaking about the experience before the Australian courts concerning the recognition and enforcement of ICSID awards, and particularly including awards that have been issued by tribunals constituted under the Energy Charter Treaty. In the claims, many of the claims against Spain, and I've been involved in those. I've been acting for various award creditors who are seeking recognition and enforcement of their ICSID awards over the last few years. And the issues that have been teased out before the Australian courts include, of course, Spain's assertion of immunity from the jurisdiction of Australian courts in these proceedings for recognition and enforcement. And there are a number of proceedings underway, but one of them, one of the first two that were started about 4 years ago, has been appealed all the way up to Australia's High Court, which is our superior court, our highest court in our court hierarchy. And the High Court of Australia gave its judgment in mid-April, just over a month ago, in favour of the award creditors in that case. And that was the Antin case. So Infrastructure Services is the new name. The name Antin was dropped off after the ICSID proceeding concluded. And the High Court judgment was a unanimous sort of 7-0 judgment, even with a single unanimous judgment of all 7 justices, holding that Spain had submitted to the jurisdiction of the Australian courts in proceedings for the recognition and enforcement of the ICSID award. And the judgment is quite significant because it is one of the first judgments of a superior court of a contracting state in which the interpretation of Articles 53, 54 and 55 of the ICSID Convention have been tested, and their relationship with assertions of immunity. Now, going back to the beginning, the proceedings were brought in Australia under Australia's International Arbitration Act, which implements Australia's obligations under the ICSID Convention and gives it the force of law in Australia. There is a relatively straightforward process, or it looks straightforward anyway, in the ICSID Convention in Article 54 for seeking or achieving recognition and enforcement, which is simply that a party seeking recognition and enforcement of an ICSID award in the territories of a contracting state shall provide to the competent authority or court a copy of the award certified by the Secretary General of ICSID. And so the proceedings were commenced, and Spain made a conditional appearance for the purposes of asserting its immunity from the jurisdiction of the Australian courts. And it did so under Australia's Foreign States Immunities Act. And the way that legislation operates is quite similar to the UK State Immunity Act and the US Foreign Sovereign Immunities Act. which is that it sets out a general rule of immunity from jurisdiction subject to a series of exceptions. Now, the award creditors argue that there was an applicable exception to the general rule of immunity from jurisdiction, and that exception lay in the fact that Spain had submitted to the jurisdiction of the Australian courts, and that it had therefore waived its immunity from jurisdiction within the meaning of Section 10 of the Australian Foreign States Immunities Act. And it was argued by the award creditors that Spain's submission to the jurisdiction of the Australian courts could be found in Article 54 of the ECT Convention, of which Spain is obviously a contracting state. And under Article 54, as this audience well knows, contracting states agree that each contracting state have an obligation to recognise an ECT award as binding, and also to enforce the pecuniary obligations imposed by the award within its territories as if it were a final judgment of a court in that state. And so, as the award creditors argued, because Spain was a state party to the ECT Convention, it had agreed that all of the other contracting states, including Australia, had an obligation to recognise ECT awards as binding and to enforce the pecuniary obligations arising under the awards. And that was in effect a submission, a consent to the jurisdiction of the Australian courts to do that. Now, Spain, for its part, argued that no, it had not waived its immunity as a matter of the Foreign States Immunities Act. It argued that any kind of submission or waiver of immunity had to be express, and because this wasn't expressed, but it was being achieved by sort of a route of various implications, that wasn't sufficient. It also argued that as a matter of the ECT Convention and the interpretation of Articles 54 and 55, it actually preserved its immunity from proceedings for enforcement of the award. And this was primarily because of a linguistic quirk in the English, French, and Spanish language versions of the ECT Convention, each of which are equally authentic and authoritative. Article 55, of course, provides that nothing in Article 54 shall derogate from the law relating to immunity from execution in the relevant contracting state where recognition and enforcement is sought. And Spain argued that because the French and Spanish language versions of Article 54 and 55 use the same term to refer to enforcement and execution, that should be understood as meaning that the preservation of immunity from execution also extends to preserving any immunity from enforcement that Spain was able to rely on. And so because of, and it did so because the French and Spanish language versions use the same term, whereas the English language version has two different words. One is enforcement and one is execution. Now, at first instance, the federal court found for the award creditors in the two cases that were heard together. One was ISA and the other one was Anti and Infrastructure Services. And the ISA case then fell away when it went to the full court of the Federal Court of Appeal because the award had by then been annulled. The appeal went to the full court of the Federal Court, and Spain was unsuccessful there as well. It then applied for special leave to appeal to the High Court of Australia, which granted special leave. And the High Court, as I said earlier, rejected Spain's appeal in a 7-0 unanimous judgment. It largely upheld the conclusions of the primary judge and characterised the proceedings as being for recognition and enforcement of the ECT award. On the linguistic issue, the use of the same term for both enforcement and execution in the French and Spanish language versions, the High Court said that this had to be understood against the civilian process of exequatur in civil law systems, which encompasses both recognition and the step by which a court gives an arbitral award the force of a domestic judgment. And so understanding that background, the way that aspect of civil procedure in civilian countries works, there was no real difference because between the English text and the French and Spanish texts of Articles 54 and 55 of the ECT Convention. Now, on the EU law issue, the High Court addressed the matter that Spain had raised, but didn't fully develop on ACMEA and Comstroy. And the High Court rejected this. The argument there was, of course, that Article 26 of the ECT was invalid as a matter of EU law, so it wasn't possible for an EU member state to offer to have an arbitration with a private investor for another EU member state under the ECT. Now, the High Court rejected this because it had found that the submission to the jurisdiction of the Australian courts was not found in the ECT, but it was found in Article 54 of the ICSID Convention. So whether Article 26 of the ECT was invalid as a matter of EU law was simply neither here nor there for the High Court of Australia. I'll end my comments there because I know we'll probably have some Q&A to move on to now, but that's just a quick overview of the High Court of Australia's judgment in infrastructure services. Thank you very much.
Thanks so much, Chester, and thank you to everybody, because I think we've made clear from this panel both that things remain completely unsettled inside the EU, and that those of us from outside the EU looking in will continue to have to wrestle with what to do with it anyway. Right? We can't wait and see how the EU settles itself out. Because there are ongoing proceedings, and the courts and even those who are considering their treaties are going to have to decide how to proceed. So I think there are still a lot of open questions ahead of all of us, and we will continue to watch this space. Maybe we'll convene again next year and see how we've progressed. I know that Jose Antonio, you can confirm on this that I think for the sake of the World Arbitration Update participants, we were planning to break out into sort of networking breakout sessions where we can continue some of these conversations individually. Before we do that, of course, though, I would like to say thank you so much for the whole panel, for all of these comments and for posing all of these questions that remain unresolved. So I think it's been a wonderful session.
Yeah, thank you, Maureen. Yes, I'm happy to confirm that that we will be sent by the WOW team to the breakout rooms, and just as an administrative matter, in the breakout rooms, we're not compelled to talk about substance. You can talk about whatever you want. People, no, there's no, we're not in the proceedings as such. Of course, you're happy, if you're happy to talk about it, that's fine. We have about 45 people still in the conference, so it might be good to have the WOW team send us to a breakout room.
Great. And I really do encourage everybody in the audience to take advantage of this 10 or 15 minutes. It is a great chance both to talk to the panelists and to get to know each other. I mean, the whole point of connecting the world in World Arbitration Update is to allow us to make these connections. So let's take advantage of it.
And thank you, Maureen, for the incredible moderation.
Wonderful. So thanks all.
Ronald DC, what are your views on the ECT?